in this workshop is to use this as part of our larger research to see how this DPA could work as an effective regulator in India. Indian regulators have historically struggled with capacity issues, and data regulation is a new field of regulation. No Indian regulator has dealt with data regulation issues in a comprehensive way before. So to discuss this issue today, we have a set of eminent speakers. We will begin with presentations by my colleague Suyash and myself, and we'll set out the issues and present some initial thoughts for the first 30 minutes of this workshop. After this, we have Ms. Rosalien Stroot, a senior policy advisor from the Dutch Data Protection Authority, Ms. Annabel Lee, who leads the public policy work on data issues at Amazon Web Services, who will join us shortly, and Professor Ajay Shah from Jindal Global University. And at the end, we'll take some questions from the audience. Please feel free to put in your questions into the chat box either on Zoom or on YouTube. So without further ado, I'll request Suyash to start his presentation.
Thank you, Anirudh. I hope you can see my screen. I've shared my screen. So, hello everyone. In the next 20 minutes, I'll give you some ideas from our research on how to build an effective data protection authority. What is the right approach for it? And I'll give you an outline of the argument right away. So the basic argument that I'm making in this 20 minutes is that data protection regulation is an unusually complex form of regulation. We have not seen anything like this before. The traditional forms of regulation in sectors like banking, electricity, infrastructure do not compare with this. It's a unique form of regulation. In India's context and the way the proposed law has been designed, this complexity is only going to increase, and I'll argue why that is the case. And the final part of the argument is that the regulatory regime that we build in India should try to harness this complexity to achieve its objectives instead of trying to limit the complexity to make its job a little easier. So that's the outline of the argument, and I'll make this argument in three parts. First, I'll share some basic facts about India's proposed data protection law and regime. Then I'll do a little bit of analysis on what is the nature of data protection regulation, especially as proposed in this regime. And finally, share some ideas about how we could go about starting to build a data protection regime. So the issue of data protection is at the junction of three different movements that are happening parallelly. One is on the jurisprudential front. About 4 years ago, the Supreme Court of India read the right to privacy into the Constitution. And it was the way it was set up was that a 9-judge bench was created to look into this question of doctrine on whether there is a right to privacy in India. And the response from the bench was in the affirmative. And they also included informational privacy as one aspect of privacy there. So it was a doctrinal pronouncement from the bench, and much jurisprudence is yet to be developed around it. The kind of grounded jurisprudence that comes from specific cases will evolve rapidly now that there is this pronouncement, and that will shape data protection in India. The second is that although until now we have had a very minimal framework for data protection in India in the Information Technology Act, Telegraph Act, some sector-specific mechanisms, this bill that is in the Parliament right now constitutes a major leap towards having a data protection law in India. So we're going from somewhere 10, 15 out of 100 to say 80, 85 or 90 out of 100 in one leap. And how this works out will define how data protection in India actually happens. And finally, as far as the administration side of it is concerned, the establishment of data protection regulator authority itself is a major leap because we don't have any authority or data privacy commissioner or anything like that, which is supposed to look into this matter right now. So it will be a major leap and it will have to be established, and how it works will shape data protection. Now, once the regime comes into being, it will create its own taxonomies and categories. And this is a partial outline of what will the system look like. So there'll be data fiduciaries who will be processing the data, and data processors will process on behalf of data fiduciaries. And then there'll be data principals who will be the individuals whose personal data is being protected. There's a category of subcategory of children for whom there are special provisions provided. Unlike GDPR, there's also a provision of significant data fiduciaries on whom some additional obligations will be applied. And interestingly, the law provides for some intermediaries like consent managers who will help the data principals interact with data fiduciaries. and data auditors who will create artifacts like data trust scores or data privacy impact assessments to enable this system. And then there are state bodies, including the Data Protection Authority. Union government also has rulemaking powers. There's an appellate tribunal to which the decisions of the authority can be appealed. And then, of course, the higher judiciary, specifically the Supreme Court, to which the appeals from the appellate tribunal itself can go, and the Supreme Court will anyway play a role to building jurisprudence around it. That's the kind of system that will come into play. And Data Protection Authority is one part of the system. It's not necessary. It is probably the most important part, but it is not the only part. All of the parts have to work together to create the outcomes on data protection. Now, how is the regulatory design in the law itself? So, if you look at the law, there are basically two types of regulatory interventions that I emphasize. The first part is to regulate the interaction between data principals and data fiduciaries. So that's going to happen through regulating the notice and consent framework, the minimizations, different types of limitations that are placed in collection, storage, and processing. Then the grievance redress that is done by data fiduciary itself will be regulated, and how the data principal will exercise their rights will also be regulated. And the other, so it's not just about these interactions that is happening directly. The other important part of it is that the systems and policies of data processing, personal data processing itself will be regulated through by the Data Protection Authority, and that's happening at the back end mostly. Data principals will not be directly involved in it. So there are some general obligations that are applying to all data fiduciaries, and then additional ones that are applying to some categories. And to make these two strategies work, there are different kind of powers that are given to the Data Protection Authority. They have power to regulate some of the intermediaries, as I said earlier, the consent managers, the auditors. They have the power to limit the boundaries to some extent, not significantly, but the flow of data across borders will be a role that DPA will play. There will be some powers to define anonymization standards and so on. And there will be a mechanism of codes of practice, which will basically be a form of enabling self-regulation, but in a regulated manner. And then there'll be enforcement and redress functions, and creating awareness about data protection also function regulator. Now, this is broadly based on GDPR, but it's very different also. It's important to just highlight this. I will not go to details. It is a regime that is borrowed, based partially on GDPR, but it is very different. So there are some categories that simply don't exist in GDPR, like, as I said, significant data fiduciaries. The idea of having hard localization of critical personal data is not there. The performance of contract is a ground for processing GDPR, but it's not there in the Indian jurisdiction. On the other hand, GDPR has direct provisions on safeguard against harm from automated decision making, which is not there in the Indian proposed law as of now. And then there's a provision that allows non-personal data to be accessed by government, which is not there in GDPR. And again, different from GDPR, that the Indian law has very broad exemption given to power of exemption given to the government. The government can exempt its own activity from this law based on certain grounds given in the law. So that's the overview of the regime. I'm not going into too much detail, just giving an overview of what's there. And so analytically, there are some complexities that are permanent and that are inherent to the nature of data protection regulation. It's worth thinking about these complexities when we are trying to build the regime. So these complexities are in two levels. One is at the level of the law, and the other is the level of the regulatory system, the system that will be regulated. And the legal complexities are inherent to the law itself. So one level of complexity there is on the subject of regulation. What are we regulating? So the way the law is presented, it broadly tries to protect personal data. But in practice, regulator will have to deal with this complexity of we need to protect personal data, we have to think further from there, that in potential context, information, diseases that can be taken on the basis of the personal data, what harms can come. So that is a permanent complexity that the regulator have to deal with. Second are the purpose of regulation. As I said, even though it's supposed to be a personal data protection bill, in practice, you know that there are different people have different expectations of privacy, different trade-offs that they are thinking about. In practice, harms and benefits are often very difficult to disentangle and foresee. For example, in social media, the benefit of social media is often very closely tied to the harms of surveillance and all of that may come with it. And there are also platforms which the more we use, the more utility we derive, but then we also empower the platform to see more of us. So these kind of issues need to be disentangled. And then, of course, at the level of society, there are different interconnected and conflicted interests. So my personal data protection interest may be different from another person who I'm interacting with, and whose interest will prevail in which situation is a permanent tension for the data protection authority to resolve. And then there are other values that may be at play at a given situation. So data privacy is one value, but there may be other values, and those also the data protection authority may have to consider while making its regulations. And to add to this inherent complexity of the law, as I said earlier, the lack of coherence in Indian jurisprudence on this issue also matters, because more coherent jurisprudence would have given some guidance to the data protection authority, also perhaps delimited their discretionary powers to some extent. So that's on the complexity of the law. Then there are complexities that are inherent to the regulated system itself. The one fundamental complexity here is that we are empowering the state to infringe upon privacy, to protect privacy. The DPA will have the power to monitor and surveil almost the entire digital economy, and it will have to be basically reined in some ways. Otherwise, it may create its own problems. While the original conception of this right came from trying to protect individuals from the state itself. So this is a permanent feature, and it will need to be continuously monitored and ensured to citizens and elected representatives and so forth to ensure that this problem doesn't become too big. Then the problem of boundaries. Unlike many other regulated systems, here the boundaries are very blurred and highly always changing. So there are the global internet. India is part of a open internet. So until now, and it's very easy to move data across boundaries, across systems, and it will change forms while it moves, but it will still be about the same person perhaps. And that makes it difficult for a regulator to understand the boundaries of the system it is regulating and try to regulate it. And then the scale of interactions that are to be regulated, they are not just large number, they're also ever growing, and you can't really control and shouldn't control perhaps interactions. That it's not a finite resource to be protected. They are just personal data is created every moment, and every interaction adds to the complexity of the regulatory task. Then there is this kind of subtle complexity of the fact that, as Larry Lessig said, code is the law, that there is certain norms and kind of laws, quote unquote, that are implied in the law, in the system that are currently there in interactions. And they have some implied values. And those need to be now reviewed and intervened by the regulator. And that may create its own unforeseen outcomes. And finally, the kind of system we're talking about, the digital economy, data systems, are highly unpredictable, because who could have foreseen 10 years ago the way Facebook will develop or the way Google will develop? These are highly unpredictable systems. The system dynamics are very chaotic, which makes planning for regulation very difficult. There are some fundamental complexities in law and in the regulatory systems that need to be dealt with in an ongoing basis. So just to summarize the differences between this regulation and other very brief way, is that in the traditional regulation, banking and other sectors that we know about, the unit of regulation is clear. There's a licensed firm and its predefined activities are being regulated. Here it's much more fluid. The boundaries and scale are substantially defined and limited by the regulator and the law itself. Here it's basically organically developing. People are interacting, personal data is being processed and created, and the regulator has to just deal with it. And objective is much more focused in traditional regulation on harmful outcomes. It's basically, when you talk about risk, you talk about risk of harmful outcomes. Here it focuses much more on compliance failure. So processing of personal data itself is being prevented and regulated, and what harmful outcomes may come is what downstream from there. So these are some interesting differences which need to be considered while building the regime. Now, with this background, how should we think about building the data protection regime in India? And one thing we have to keep in mind here is that we are basically drawing on a blank slate. So there's an opportunity to think from first principle. Instead of feeling constrained, there can be an innovative approach. And so I'm going to talk about it in three parts. First is, how do we develop a regulatory strategy that harnesses this complexity rather than trying to limit it? Second is, how can we do some capacity building in the organization before the law is passed and notified, so that it hits the ground running? Finally, I'll talk a little bit about questions of independence and authority and accountability of the authority. So this slide basically summarizes the way I see this complexity and harnessing of the complexity. that the strategic objective of a data protection authority should be to, I mean, it's not something to be done overnight, it will happen over time, is to gradually shift the system that it's regulating towards selecting more privacy respecting processing strategies. So today you have some processing strategies, maybe which may be privacy respecting or more compliant with privacy values, and some that are not. Gradually you have to move the system towards selecting more of the former than the latter. And it's a process in which you have some influence and everybody else will react to what influence you exercise. And that's the way it should be seen. If you try to see it as something to be made, you have to make a standardized rule and implement it on day one, it will not work. That's the way traditional regulation is supposed to generally work. Here, it's much more of an adaptive and evolutionary approach that is needs to take. So, flowing from that, I think there are some key elements of the regulatory strategy that you kept in mind. One is that you have to allow a lot of variation in the behavior of entities because you're dealing with a varied set of entities. So the data fiduciaries and data principals are very varied in their values and what benefits they're creating for each other. So you need to create much more sector specific and other kind of variations in behavior of entities within the framework of the law. While you are allowing variation, you also have to create awareness about what are the criteria for data privacy so that people can select from the variations in a manner that is more privacy enhancing. So issues, you have to use data scores by data principals and others. You have to harness into networks of volunteers who are privacy advocates who look at these policies and report on the problems and violations so that you can slowly start selecting. Second is that this law interestingly allows for some of these intermediaries like consent managers and data auditors and so forth. These have to be leveraged much more in a more significant way. For example, the data auditors are mostly meant for significant data fiduciaries in the bill. In our view, it should be more broadly applied, the idea of data audits, data privacy impact assessments and all, so that you have better information without increasing the direct supervision requirements of the data protection authority. So intermediaries should be harnessed much more so that they can be more, again, this has got to do with creating more varied strategies and also regulating the interactions. So when a data principal is interacting with a data fiduciary, there should be some intermediation through entities like consent managers. Then when you talk about the interactions themselves, we have learned from other sectors that the structure of interaction really matters. How much time do you get to decide? Can you reverse your decision? Those kind of things. And those, the EPA has the power to regulate, and those powers should be regulated, should be used to regulate the structure so that the decisions are more deliberate and can be taken in a more careful way. And then the DPA will have some finite supervisory powers. It will have some inspectors and investigators who will go and find out things, how things are going. Those should be a risk-based framework should be applied there. We are working on a risk-based framework where we are focusing on this, combining the idea of risk of compliance failure and harms. So that you can apply your resources in a more careful way. And then you need to obviously build ongoing learning system. It's a very complex system. You can't foresee how it's going to develop and what kind of changes can happen in just a matter of few months. It's far less stable than other sectors that we know. So these same ideas I presented in a more tabular format, just to contrast with the other traditional forms of regulation that we all know had developed in the 20th century. Regulatory perspective in those sectors is more top-down, that you are basically overseeing entire sector. Here is more peer-to-peer. You are a part of an ecosystem and you're trying to use your limited powers to try to nudge the system towards more better privacy respecting strategies. The instrument of regulation in traditional regulation is much more controlled. So you make a rule, you implement it, and that's the way it goes. Here it's much more of a nudging and influence kind of approach where it's too vast and too complex a system for you to control and run in a command and control way. You're looking at finding ways to influence so that the strategies that are selected are more privacy enhancing. Method, again, as I said earlier, so planning and implementation is focusing more on adaptive kind of strategies. Standards in traditional regulations, there are much more uniformity is achieved, and then some exceptions created for special categories. Here it's inherently varied because the privacy values are varied for data principals, and the context for data fiduciaries are very different. So there will be much more variation in standards. Epistemological question about how you learn and all. In typical traditional regulation, the gold standard is collecting more and more information, gathering, analyzing it, and using that knowledge to formulate a neat-looking regulation. Here, you have to count more on the others' knowledge also. You have to learn yourself, but you have to count on others' knowledge to be able to take decisions, and that you are not the repository of all the knowledge that exists. Organization design will also have to be reflected. It cannot be the typical bureaucratic organization that regulators have. It will be some version of a bureaucracy, but it will be much more open. And the question of dealing with problems and complaints and failures, in typical regulation, you are looking to look at it is a more comprehensive way. All the complaints should come to you and you process them and you punish. Here, it should be much more exception handling and allow more self-regulatory mechanisms to work. Now, just take one or two more minutes So the law is in the parliament right now. It will take perhaps a year. We don't know, 6 months, a year, maybe longer to come out. But if we are arguing that there should be some preparatory work done in advance before the law comes, because of all these reasons, you need to learn, you have to develop a sophisticated regulatory strategy. So there should be an authority set up through an executive order. It will not have the powers of the law, obviously, but it can do a lot of preparatory work so that it can get started. To begin with, we are arguing it should be a small organization, about 50% or so, 40-50% to begin with, which will develop these strategies and start developing the internal policies. And initially, when the authority is set up, it should be allowed to experiment with this kind of a decentralized or adaptive approach in a few sectors. Learn a little bit, and then it should be allowed to function. So that will affect how the law is notified. Or the entire law shouldn't be notified on day one. It should be gradually notified so that the authority has the ability to learn more. And my colleague Anirudh will talk more about that aspect. Finally, this is a very, as I said, it's a very complex form of regulation. Accountability and independence will both be very difficult, complicated because of this. Because can you hold a data protection authority accountable for all the privacy outcomes? The privacy outcomes will come out of many other factors also. Only some of those factors are controlled or influenced by the data protection authority. So we are arguing that the broader, thicker versions of accountability will develop over a period of time through cultural, political mechanisms. But some thin versions can be built in, so which will be around transparency of authorities' activities and use of inputs, so better release of statements, explanation for the decisions through issue of statements, and those are powers that are currently given in the law to the government. Prescribe rules, and the government could make those rules and prescribe them so that the authority can start with at least a basic function of accountability, and then it will expand over time, become thicker, more culturalized and socialized through the improvement of awareness of the issue. On the question of independence of regulation, as I said, the law is set up in a manner that the government is very powerful. Government has the power to influence not just the exemption giving powers, but also give direct directions to the data protection authority. So it is not as independent as as a gold standard is supposed to be. So, but even then, you can try to do a little better on that. For example, when the power of government intervention in the authority decision that is given in the law, if there are rules that describe on what grounds the power will be used, it will be a little bit more independence enhancing. Similarly, on questions of appointment, removal of members, terms of members, there will be rules that will be prescribed, and those rules should be such that there is a standardization and transparency in the way these things will happen. And then over time, this independence and accountability will develop. We don't think this is the kind of regulation you can design and put on. So these are the three aspects. So on the question of regulatory approach, regulatory strategy, building capacity, and independence and accountability. I'll stop here.
Thanks, Suyash. I'll just share my slideshow with you. Suyash, if you can just stop sharing this.
Yeah, let's stop.
Thanks. So I'll take about 10 minutes to talk a bit more about questions of prioritization. And the idea behind this is to focus a bit more on what the regulatory capacity of the DPA should be directed towards. And this is something that is going to be critical, especially in the first 2-3 years when the DPS capacity will be fairly limited by definition. It will be a small organization. And as Suyash has explained, there is a vast amount of work that the bill in its current form requires the DPA to do. And so everything from regulating standards of notice, consent, to actually monitoring compliance, to enforcing penalties, and so on. And the capacity that the organization will have in the first 2 to 3 years will be fairly limited. So the question is, how do you actually create some sort of criteria or framework to prioritize certain functions that the DPA should actually focus on for the first 2 to 3 years, while it is also thinking about the questions of how to build up the organization, what are the burning issues that the authority should actually be looking at in the medium to longer term. So what we've done is to, again, take guidance from the Personal Data Protection Bill. And this is something Suyash also talked about, that in contrast to a lot of other regulators, here the emphasis is on monitoring compliance and from reducing risks. But in contrast to the EU GDPR and some other legislation, the Personal Data Protection Bill actually has a lot more consideration of what kinds of harms matter in terms of data privacy. And the whole idea of harm and significant harm has actually been defined in the bill, and they've also been used in different places in the bill. So for example, they've actually been either used as considerations that data fiduciaries and businesses should actually think about when they're performing certain data processing activities and collecting certain kinds of data. At the same time, at other places, the concept of harm has been used to tell the central government and the DPA to use it as a consideration when they're actually making standards and creating regulations. So for example, when data fiduciaries take consent for collecting sensitive personal information, they're required to think about what the information would mean, or processing that information would mean from the point of view of causing harm. Similarly, the government and the DPA are required to think about the categories of data that would actually lead to significant harm. Some kinds of processing activities of children's data are prohibited if they are likely to lead to harm. Similarly, a lot of preventive obligations that data fiduciaries are supposed to set up, like security safeguards, impact assessments for future use, are all required to be taken with the consideration of likely harm. And even the DPA is required to enforce penalties, to provide for compensation based on the degree of harm that's been suffered. So unlike a purely risk-based preventive framework, there is a much more active consideration of the concept of harm within the PDP bill. And we think that's one way to think about how to prioritize and focus the DPA's activities in the initial period. So when you look at the definition of harms, there's actually a wide gamut of harms or injuries that are actually covered within the definition. And it varies from physical and mental injury to identity loss, identity theft, financial loss, discriminatory treatment, losses of employment, any restrictions that are placed because of a fear of surveillance, and surveillance itself. So this is a fairly large list of injuries that are actually being considered within the whole idea of harms. And we think the DPA should at least try and focus on activities that would lead to harms and try and prioritize those functions where the likelihood of harms being caused are higher. So we are going to basically try and address 3 questions that follow from this, which is what problems that lead to harms cannot be solved by markets, and that's a natural space for the DPA to focus on. And the second is there a way of thinking about these harms more specifically and in a more fine-tuned and tailored way? And the third is which groups are more susceptible to being harmed by the use of data? So when we talk about market failures and harms, some activities that actually cause harms can and are in fact being solved through markets, if not completely, at least partially. And data breaches are one example of that. And we've seen in India that as digitalization has increased, we've seen a lot of increase in the amounts of data breaches and the kinds of data breaches across sectors that are happening. But at the same time, the cybersecurity market is also growing in response to this. So the market is creating some solutions to this. And at the margins, yes, there will definitely be issues that the DPA will have to deal with it in terms of what happens to consumers and so on. But there are at least partial responses that are coming up in the market to things like data breaches. But there are other things that are much more difficult for markets to solve by themselves. So one of these is when you have provisions in contracts that are deceptive or vague or unfair, right? And it's subtle, so consumers don't recognize it. And these are natural places for the Data Protection Authority to look at. And this is also something that regulators and other sectors do. Similarly, there could be unexpected uses of data that were probably collected for a different purpose before, but have now been used in a completely different way, leading to harms to individuals. And again, this is something that's subtle. It's not something that's immediately apparent, and markets might find it difficult to solve for it in the first place. And the third arises from the nature of certain markets. If there are very few entities who are dominant in certain sectors, it becomes difficult to create market-oriented solutions through competition. And those sectors need closer supervision and regulation. So in terms of thinking about it through the lens of information asymmetry, market dominance, I think the DPA should adopt this market failure issue framework. And we see that a lot of ideas that are also currently in the bill are often not sufficient. So they need a lot more focus by the DPA. So for example, use limitations, notice consent, these are often sometimes insufficient because users do not have the cognitive ability to understand how the data will be used, even if everything is explained in the contract through which they're giving consent. And we've seen in other sectors like finance, insurance, and so on, regulators actually prohibit the use of certain contractual wordings, clauses, and so on from the point of view of preventing this. So the DPA should actually be thinking about how to reduce this information asymmetry in some sectors, and where information asymmetry cannot be reduced in a reasonable way, it should actually be closely supervising certain practices. And similarly, in terms of market power, I think where there are very few entities in the market, data processing in such markets with monopolies and or monopolistic markets, it requires closer supervision. And here the concept of significant data fiduciaries is important, but we should not be thinking about them only in terms of size or volume of data. We should also be thinking about how they actually operate in the market and their overall dominance in the market. So the DPA should actually try to identify these market failures and try and work on those. The other is how do you actually prioritize from within the long list of harms that have been given. And here we can take some guidance from the concept of significant harm, because the definition gives the DPA the flexibility to think of what it means by significant. So it lists 4 criteria. It says the DPA should think about what is significant in terms of impact, continuity, persistence, and irreversibility. And these criteria or these factors can actually be used to develop an escalatory matrix of severity. Even if the harm does not technically fall within the definition of a significant harm, we can still have some kind of a matrix that is able to rank the severity of harm using these criteria. And the third question is about vulnerable groups. And one group, like Suyash mentioned, is about children, and there are fairly explicit requirements on the processing of data related to children. In India, we've also seen a lot of anecdotal evidence and news reports about the elderly population suffering or having a higher susceptibility to identity fraud, financial loss, these kinds of issues. And there is a bunch of literature that actually talks about how to understand vulnerability in different contexts. And it basically says that there are 2 criteria that people can use to think about who are vulnerable groups, especially in a data protection context. And this is about having groups having limited capacity for consent or understanding how their data is going to be collected and used, and groups that have a specifically greater susceptibility to harms. So again, this is something that the DPA can use to sharpen its focus in the initial period when it's still trying to build up its capacity. So what we get is, if we are actually able to draw these kind of spheres of regulation, the areas of overlap where one or more of these circles overlap should be the areas of prioritization of the DPA. And this is where it should try and make sure most of its focus is on for the first 2 to 3 years, when it's still trying to figure out a long-term approach to regulation in the sector. And this will require a different approach. And Suyash has explained the nature of regulation itself. we've also done some basic research to try and understand how looking at past and present trends on news sources, industry sources are not always a good predictor of future trends. So we've actually looked at industry and news reports on data protection issues for the last 5-6 years in India. And we searched for all incidents and issues related to data privacy violations, which would have been covered in the PDP bill if the bill were in force. And what we've seen is that news reports generally track policy developments rather than the other way around. Right? And second, the bulk of news reports and industry reports focus on data breaches, which leads to a blind spot on what else is going on. So if you look at the concentration of news reports over the years, it's escalated or increased significantly as the debate on data protection has improved or has gained in importance over the years. And similarly, when we try and do a subject matter breakup of incidents of news reports, the bulk of these are on data breach related issues. Some of these are also related to issues of consent and unlawful processing. But most of the other activities that would be covered under the data protection law are actually not covered here, which is the reason we need different kinds of regulatory approaches. We need a more decentralized, more open learning kind of approach that Suyash was talking about. And that should then be directed towards thinking about harms in a more systematic manner. So I'm going to stop here, and I'm going to pass on to Ms. Stroot to talk about her experiences in the Dutch DPA on some of these issues. Thank you.
Thank you. Thank you, Anirudh. This is really interesting times for data protection in India, with the bill now in waiting to be passed in Parliament. So it's really interesting to hear both your presentations, and thank you for having me on this panel. My name is Rosalien Stroot. I work at the Dutch Data Protection Authority in the Netherlands already for quite some years. First, I was working with complaints, but now I'm in the international field. And today, within 10, 12 minutes, I would like to walk you through our development. We already were established in 1989, so already quite some years, but we are still learning, still also evolving. So it's interesting to hear how you're now on the brink of setting up a DPA. And I would like to share with you some of our structure, organizational information. So I'll start with the legal framework of data protection in the Netherlands. Then I'll move on to the structure, the composition, and the budget of the Dutch DPA. Then I'll move on to the independence of the Dutch DPA. It was already mentioned by you both in the presentations, how important it is to be independent as a data protection authority. Then I'll move on to some public awareness, our website, etc. And to conclude, I'll focus on our focus and on our international cooperation briefly. And normally I like an interactive presentation, but I think because this is online, it will be best to keep the questions till the end when we have the discussion, but more than happy to take questions. So for the legal framework of data protection in the Netherlands, there are 6 important data protection laws. Obviously, we have the General Data Protection Regulation, the GDPR, where you have also based your bill on, if I understand, you're basing the bill a lot on the GDPR. We had it implemented in May 2018, so now already for 3 years we have the experience. And along the GDPR came the Dutch Implementing Act of the GDPR. So this is our national law to implement the general regulation from the European Commission. So we have a national law implementing the regulation. Furthermore, we have the Police Data Act. I won't bother you with the Dutch pronunciation of that. It's in brackets behind. But also the Judicial Data and Criminal Records Act. These are different laws. Also the Dutch Electoral Law and the Basis Registration of Persons Act. That's our Citizen Number Act. And the Dutch DPA is the competent authority to supervise compliance with all these 6 laws. So we are the supervisor for all 6. That's our task. So if we look at our structure, our organizational structure of the DPA, you see on top we have the board of the Data Protection Authority. It consists of 3 members. So in my next slide, I'll go a bit more into detail of that. But we also have an advisory board. So this is an independent board of some politicians or former politicians, but also academia, people from university, who really can advise our board, but also our members. So once, I think a couple of times per year, our board would have a meeting with our advisory board. They would just sit together. Now it all goes online, of course, because of COVID-19, but normally they would really join, interact, share ideas, and this advisory board is truly independent. So they give advice on any kind of matter. So we find this an important aspect of our DPA, of our independence, but also our functioning. Then below these, under the board of DPA, we have 5 directorates. So you have the customer contact and national inspections. Then you have the system supervision, security, and technology. So system supervision is something new we introduced in 2018 when implementing the GDPR. Then we have a department, legal affairs and legislation advice. Then we have the directorate, policy, international strategy and communication. That's also my department because the international advice falls under this directorate. And then we have business operations. That's more, for example, HR, the administration, running of the DPA. So these are the 5 directorates with 14 departments below them. So if we move to the next slide, then I'll tell you a bit more of the composition of the board. Currently, we have 3 members of the board. This is our chairman, is Mr. Aleid Wolfsen. And we have 2 deputy chairs, 2 ladies. That is Monique Verdier. She's one of our she's also the deputy chair of the Dutch DPA. And we have Katja Mur as one of our board members. And then, as explained, 5 directorates. Previously, we had a general director, but now we only have, for every directorate, we have 1 director. 14 departments, and at the moment we have 179 FTE in total. I must say this is the number of the end of 2020. It fluctuates a bit, so let's say 180 in total. Sometimes people leave, sometimes we colleagues join, but in general this is around 179, 180. And we increased also because when I started 10 years ago at the Dutch DPA, we were only with, I think, 60 or 70 FTE. So the last couple of years we increased tremendously. We really had more personnel because following GDPR we also had additional tasks. So that's for the composition. Then we'll move on. I think this might also be interesting for you because you're now on the brink of setting up the DPA. So how would you appoint a chairman and members of the board? So in the Netherlands, we have this organized within our implementing act of the GDPR. So the GDPR has some rules and regulations, and we have this in our national act. So the procedure is as follows. There is a recruitment by an objective selection committee and advice of the Works Council. Then this selection committee nominates a candidate and presents the candidate to the Minister of Legal Protection. Then after advice from civil servants, the Minister of Legal Protection nominates the candidate to the King. I don't know if you know, but the Netherlands is a constitutional monarchy. So there is still a role of the King to sign off, appointed by royal decree, the chairman of the DPA. And then afterwards, a public announcement follows in the government gazette, announcing everyone we had a new appointment. So if you can appoint members, you also should be able to dismiss them. So that's my next slide. Dismissal of a chairman and members of the board is laid down in Article 7.7 and Article 8 of the Implementing Act of the GDPR. Dismissal is possible after a maximum of 2 terms of 5 years. So any board member, being it the chairman or board member, cannot stay longer than 10 years. That's the maximum. Of course, if they have for personal reasons or they would like to retire, they can dismiss at own request. They can leave earlier, or following a disciplinary action by the Supreme Court. So the dismissal is done again by royal decree and public announcement in the government gazette. So then if we move forward to the structure of our organization. So I just mentioned we have around 179 FTE. So this is composed of our board. You don't see 3 FTE because some of the members work part-time. So that's why it's 2.67. As I also explained, we don't have a general director anymore. We had one till 2018, but then afterwards we just had the 5 directorates. So that goes from 1 to 0 in 2019, 2020. Then we have the Department Business Operations, System Supervision, as you see, only established in 2018. Then the Customer Contact and National Inspections, that was already previously there, but we had a reorganization with implementing the GDPR. We had quite a big reorganization, and therefore colleagues have been shifted internally. The last couple of years, it has been the structure as it is, but in 2018, we had this big reorganization. Then we also had this Policy, International and Strategy Department, Communication, of course. For example, they provide the press releases, they keep our website up to date, and then Legal Affairs and Legislative Advice, coming to a total of 179. So if we go to the next slide, I'll explain a bit more. I think that's also interesting maybe to share with you. How do we train our new personnel? Also the personnel that was already there, but also new employees. What do we provide them with? So as soon as they entered, of course, they get set up with everything. But also we have this experience because we had so much pro the last couple of years. So what we do is that we find it important that every employee needs to follow the internal GDPR course. So it consists of 2 sessions of each 3.5 hours, and they will focus on the GDPR. So while they focus on privacy and data protection as a human right. So they will go to the charter where it is all enshrined in law, and they will move to all the history also for data protection. But then, of course, the focus is on the GDPR from the perspective of the data subjective and the perspective of the controller. Both are addressed. So perspective of the data subject is, of course, Article 5 GDPR, the concept of personal data, data subjects, the processing of your data, your rights, right to be forgotten, for example. So that's all being addressed. Then also from the perspective of the controller, for example, someone working at our front office, they would pick up the phone, have telephone calls, questions, inquiries from companies. So they need to know the legal basis or the relationship with the processor or the data protection impact assessment, DPIA, or maybe we have questions from data protection officers that have now been established with the GDPR. We have DPOs, maybe a DPO from a hospital. They would give us a call, provide us with a situation and would ask, can you think along? What should we do? And of course, data breach notifications. The Dutch DPA was quite, a pioneer with data breach notifications. I think we already had them in 2016 because they were obligatory. They came obligatory with the GDPR in 2018, but we already had this experience from 2016 that Dutch companies should report when there was a data breach. So we already had the experience, and then in 2018 it was further formalized within the GDPR. But we get a lot of data breach notifications every day, and this is also something that increases our workload. So how do we get paid? How do we realize work? So this is the question on the budget. That's always interesting. I think it's also an important topic for you because you now need to get established if the bill is adopted and setting up the DPA. So if you look at our budget, I took the budget, is also on our website available for the last 4 years. So 2017 to 2020. So you see from 2017 to 2018, we had an increase, quite severe, quite big increase in our budget because then we had the GDPR to be implemented. So we always, these are huge amounts but still it's not sufficient for our work. So we really had to lobby back in 2016, 17, flagging to the Minister of Justice, Peace and Justice, where our money comes from, to really highlight the importance of more budget because of our increasing task. And as you all will understand, it's all government budget. It has to be divided also to the police, to the legislature. Everyone wants the same money, and it's every year also a lobby to get the amount of money. But as you can see, our budget increased from 2017 to 2018. We also managed to increase it because we had more and more workload. 2019, 2020. There are, of course, 2021 and 2022 are now under negotiation. Still 2021, so I could not provide you with that number. We are still really much working to have at least the same amount or maybe a bit more budget to fulfill our tasks. But this is a recurring topic also with European colleagues. Everyone says, hey, we cannot keep up with all complaints coming in, dealing with complaints. This is a recurring topic, and everyone is really trying with their governments to get extra money to fulfill the task, because our supervision is quite broad. Privacy is everywhere, from hospitals to schools. And also mentioned in your presentation, we have also a digitalized country. A lot goes online, and even with COVID-19, the last years, you probably would have seen the same. So much more is online, and this is great. It's a great thing, but it also brings along huge risks. And I'll get to that later, but you also see, and that was interesting in your slides, Anirudh, that you say, hey, we get more awareness with the public about privacy and the topics. And personally, I noticed this as well. 5 years ago, when I would talk to family, for example, of friends saying the work I would do, they would not really understand where I would be working. Now everyone knows what is the data protection, what do we do, what is privacy. So that's, I think, really because we get more digitalized, privacy matters more and more, but also because of the GDPR. So I really see a development in that, and you probably have seen the same in India and will see the same in India. So that's this slide on budget. Then the independence, really important topic. We have the Dutch Implementing Act of the GDPR to secure our independence. So Article 6.1 from the 1st of January 2019, it was established a bit later than the implementation of the GDPR. So our DPA was re-established and entrusted with legal personality. We had a huge lobby also to get this legal personality to be really independent from the government. Although of course we get our budget, but we want to be independent and decide our own where do we spend our budget on. So this was an important point for us, and it was realized in January 2019. So we can also continue appoint our own staff. So previously I was a civil servant and recruited by the Dutch government, but now I'm really recruited by the Data Protection Authority. So it's changed the status. Article 11.1 to 3, the DPA has its own budget as part of the national central government budget in accordance with Article 52.6 GDPR, and each year a budget is allocated to the DPA at the expense of our national central government budget. So we have the central government budget and we get a share of that. And it is, of course, there is a minimum, but we always try to get more. We always lobby and we always...
Sorry to interrupt, but could you wrap up in the next 1 minute? We are running a little short of time.
Yeah, perfect. So this is about the independence. Then we'll move to the next slide about the public awareness. I think that's interesting also to have just a look on our website, because a lot of what I've been talking about is online. I must say the Dutch website is much more elaborate, has more information than the English, but we do have an English website where you can find organizational information, news and publications, for example, regarding our guidance, research, fines, etc. You can also find us on social media, Twitter and LinkedIn. We have a data protection hotline where citizens can call us and provide us with a complaint, but they can also find 24/7 that we have a web form. They can just file their complaint and it will be processed by us. Other activities, press briefings, meetings for DPOs we organize. And of course, we try to participate as much as we can in external meetings, as I'm doing now, to just share a bit of the work we do. Then as a final slide, I'll move on to the final slide. That is our focus. I think I have one motto, and that has been our slogan also for the last couple of years: be selective to be effective. I think that's important for any DPA, especially a starting DPA. Be selective to be effective. So choose your battles, choose your topics. For us, the focus for 2020 to 2023 is data brokering, digital government, and artificial intelligence and algorithms. And then to conclude, we also, of course, interact with our European colleagues within the European Data Protection Board, but also in international fora like the Global Privacy Assembly, EU Spring Conference, GPAN, all networks that can be really much recommended as for any DPA to interact with colleagues, because your data doesn't stay within India, they go abroad as well. So that's always important to also check in with neighbors, check in with international colleagues. Thank you for your attention. I hope it was useful and happy to take any questions.
Thank you. This was really great, and it helps put a lot of our initial presentations into some context. It was very useful. Next, I'd like to request Ms. Annabel Lee from Amazon Web Services to please give her remarks. Thank you.
Hey everybody, I hope you can hear me all right. I will just share my screen in 1 second. Let me just make sure that I have the right screen. Right, there we go. Hopefully people can see it in a second. Are we able to see it? Great, wonderful. So good evening, everybody. My name is Annabel Lee. I'm responsible for digital policy issues at Amazon Web Services, so AWS. I cover a number of countries across the region, ASEAN, the whole of Asia Pacific and Japan. And prior to my time at AWS, I was from the Singapore's Data Protection Authority, the PDPC, working on data protection policy. I was there for the first 4 years as the law was being implemented for the first time. So we are pretty new regulator in Singapore. The law was passed in 2012 and was implemented in 2014. So a lot of my experiences comes from, I guess, the growing pains of being a first-time regulator and a first-time like data protection law implementer. A lot of what Ms. Stroot shared, therefore, resonated very much. And I wanted to kind of make sure that I keep the presentation fairly short today, but leave everyone with a few kind of key thought points as we go forward. So just very quickly, yeah. So I thought it would be really useful to start with the actual numbers behind a DPA. I think Ms. Stroot actually shared a great example of the complexity and how difficult, how much more headcount and budget was necessary, I think, when the Netherlands had to transition to GDPR compliance. GDPR is a pretty heavy compliance regime compared to many other regimes out there. And that means you do need a lot more resourcing and budget from the perspective of the regulator. I thought I wanted to give a snapshot of a couple of other countries just to give people a sense of what we're looking at in terms of numbers when you think about data protection implementation from the regulator's perspective. So Singapore PDPC, no, these numbers are approximate, but fairly accurate. Singapore PDPC, so we were dealing with a population about 5.2 million in Singapore, which is tiny, and about 200,000 companies. For most of these companies, they're local companies, they're SMEs, local large enterprises. So not that many actually had experiences with, data protection compliance. So the law was new for them, and they had to learn from scratch. So how big was the actual Personal Data Protection Commission, so the authority? They had about 50 people on the day of implementation. So from 1st of July 2014, actually 1st of January 2014, they were given about 50 headcount to start with. The first enforcement decision, I thought this was an important data point, probably not something that every regulator will tell you, took about 18 to 24 months from the implementation date of 1st of July 2014. Now, that was, being Singapore, that was pretty long. They were getting a lot of pressure from their minister, to be very honest, to get a decision, that first decision out fast. And it's important because when you don't make a decision as a DPA, you start looking like a toothless tiger, right? And so people, start to go, maybe they don't have to worry too much about data protection law. So it's really important to get enforcement decisions out quickly. I thought it was also important to talk about the number of complaints received. I think Ms. Stroot also mentioned what it was like in the Netherlands. In Singapore, we got about 1,000 complaints every month. So just think about the population size, the number of companies, and what that looks like in terms of numbers for complaints, which means that we had to really allocate quite a lot of that 50 people to handling complaints. So we're really looking at about 20 to 25 people handling complaints, another 20 to 25 people handling enforcement, and then the rest of the people handling policy and international relations and comms. So it's a fairly small team, if you think about it, handling each portion of this. And it's very telling what I think was prioritized overall based on needs. Another very important thing to highlight is the Singapore's data protection law is quite light touch. So compared to GDPR, compared to, I think, what we've seen in the proposed PDP bill. It's much more accountability based. It doesn't really, it's not heavy on registration frameworks. So you don't have to register your DPO, you don't have to register your company. You just need to basically have a DPO and make sure that you know your company has to comply with the law. There aren't any approval frameworks in general. There's only one portion of the law that says that if you want to get exceptions to the law, you have to write into the minister for approval. That's the only approval framework that's present. Everything else is pretty clearly laid out. And at that point, the numbers that I shared up there wasn't a data protection, there wasn't a data breach notification framework in place. So now Singapore government, the Singapore framework does have one. The law has just been reviewed, and the number of people have, in the data protection office has gone up quite significantly because of the need for data breach notification framework. Again, I feel Ms. Stroot has shared a lot of the pain, so I'm not going to spend too much time there, but it's a significant number because you think about it, you're dealing with a whole new set of notifications and complaints coming in through that channel. I also wanted to share the Australia OAIC. The numbers are accurate around 2017, 2018 when we were talking to them when I was in the government. And the population of Australia was about 25.3 million. There are about 2.4 million companies in Australia, but because of the way the Australian law works, basically SMEs are exempted from complying with the data protection law there. Only about 50,000 companies realistically are covered. Importantly, the Australia OAIC is a federal agency, so it is supported by other territory-based regulators. So you've got like one in Victoria, one in New South Wales, etc., etc. And the law excludes, as I mentioned, the law excludes SMEs. It's also not the newest regime. It's been around since 1988. So they've got a lot of experience, right? So if you're thinking 2017, 1988, they've had over 20 years of experience, and so they're as lean as they can get, and they're running a smooth operation. The OAIC had about 80 people in 2017. And when they introduced their data breach notification regime, they had to increase their headcount by about 50 people. That's what they shared with us. So you're looking at a pretty significant jump, about 40% of jump in headcount, just to handle data breach notification requirements. Again, the approach in Australia is extremely light touch, accountability based, no registration or approval frameworks. And so if you're thinking about the numbers in India, how big would your data protection authority have to be effective? I honestly can't tell you. You have a population of 1.3 billion. You have 2 million companies registered. There's no SME exception here. So all 2 million would have to be covered. If you think about the kinds of complaints that will come in, data breach notification, registration and approval frameworks that are currently being proposed in the PDP bill, and so on and so forth, it's quite a headache, but I really cannot tell you what that number is. But if you look at this, 130 is probably not going to be enough. You might be looking at somewhere in the region of 500. Now, most of my recommendations, as in the following slides, try and keep what I've just given you in terms of numbers in the back of your mind, because I think it hopefully would explain why I've made the recommendations I have. So what then does India need to do in order to structure the DPA for success? We've got a few high-level recommendations, I think a total of about 6. The first one is ensuring the independence of the DPA. I think Ms. Stroot spoke really extensively about why it's important to have an independent DPA. I think from my perspective, it's probably 3 things mainly that I wanted to highlight. The first is ensuring that the regulator has autonomy, so that it can be an effective check and balance on both the public and the private sector use of personal data. Now, whenever a new law like that comes in place, there is going to be very high expectations from citizens, right? People suddenly feel like their privacy is protected. And so there's going to be a lot of scrutiny cast on companies and their behavior, and particularly on the government and their behavior with regard to using and processing personal data. Ensuring that the DPA has a distinct identity enables the DPA to be a much more effective advocate for privacy. It means that they can say, look, we're independent, we're not being pulled in 10 directions. And if we think that this is the right balance between privacy and the need to do business or the need for the government to offer citizen services, then this is the right balance. Not having the independence means that their voice then becomes brought into question, and it becomes a lot harder for them to be able to implement and earn the trust of the population as they're implementing the data protection law. Second point is that it's really important for regulatory independence, because a regulator needs to have that institutional and financial autonomy for effective operations. I'm not going to spend too much time on that. I feel Ms. Stroot really covered it very well already, but it's just important to note that that's a really important aspect of why you need an independent DPA. And the last one is participation on the international stage. Again, this is something that I'm sharing a bit from personal experience, but the Singapore DPA is not an independent DPA, and it's been therefore particularly challenging for the Singapore DPA to join in as part of the international conversations, because it has been called to question before about their status of independence. So I just wanted to put that out there very clearly. Our recommendation is therefore that the DPA should have the power to independently develop, manage budgetary allocations, staff appointments, and other technical and administrative functions. The next recommendation that we have is to ensure that appropriate checks and balances are in place. And so what do we mean by appropriate checks and balances? As much as possible, a clear and transparent framework of obligations, so that people are sure that the way that you're treating your data fiduciaries in each case, the data principals and the data processors are consistent. This can be done in a number of ways, including publishing your decisions, publishing details around those decisions, being upfront about your interpretations of the law, for example, through issuance of guidelines, and doing so would just ensure that everybody's on the same page and able to comply with the law from the same starting point. It's also very important to have the regulator consult with the public, businesses as well as citizens, on any decisions that could have significant impact to the cost of doing business. And of course, where there are privacy concerns, then the cost on privacy as well. So it's really important that public consultation actually occurs through decisions, and this could be even in guidelines, this could be even in soft codes of practices, but making sure that you're consulting just enhances transparency. Next, decentralizing the DPA would be also really important. As I mentioned, if you think about the Australian model, they are able to run a slightly leaner central government model because they have those state regulators who are looking at it at the state level. If they didn't have that, I don't think the number of people in their office would be 130. I think they would be looking at a much, much larger number, and it would be extremely hard to coordinate. It would be extremely hard to kind of get things done, right? If they are enforcing every single case and prioritizing. So it doesn't mean that the central government DPA shouldn't have appropriate powers. It does, it should do. And it should actually oversee regional authorities where possible, so that it would ensure a certain degree of consistency between what the federal central government DPA is doing versus the ones in the states or in the regions. Another recommendation is ensuring technical competence. I think many of my presenters talked about the complexity around data processing, around the use of technology to process data can be highly technical. So you need to ensure that your DPA is well equipped with a wide range of technical competencies. I'm going to again share pretty candidly, but when we first started in Singapore, about, I would say 60 to 70% of my colleagues were not very comfortable with technology issues, if I can put it that way. So that meant that while they were very comfortable with making decisions and interpretations around the use of, or the security and the processing of data in a physical format. So like, how should we advise people to lock their filing cabinets better? There were very few people in the team who were competent and confident of talking about technical elements, like, for example, what is privacy preserving technology, and how do you advise people on when to use that sort of thing? What about encryption? How do you advise people on when to use that sort of thing? So it's really important where possible, as you're hiring out your DPA, to make sure that you've got a fair number of people who have that technical competence. There are other technical competencies as well. A legal background is very, very helpful, and so on and so forth. We also need to think a little bit about the number of people that you allocate to customer management and enforcement. And in fact, having someone who has a really good and effective way of managing enforcement decision processes and experience is extremely useful. So I mentioned about how it took a while, 18 to 24 months for that first decision. We finally got that first decision because we hired a deputy commissioner who was a former assistant registrar. So his role was, he was like a judge, you know, in some of the lesser courts in Singapore. And his role was basically in those courts to basically make decisions pretty quickly and be very clear about what they entailed. And so he was able to get through a huge amount of backlog because of that experience. So thinking about who are the right people in your enforcement team to be able to move the caseload is really important. Finally, and second to last, avoid requirements for DPAs to register, authorize, and approve activities of companies. As I mentioned earlier on, accountability frameworks, based frameworks will lessen that workload, so they can focus on more important areas like education and enforcement. And lastly, clarifying that codes of practices, clarifying that, you know, what codes of practices are, that I know that there are currently powers proposed in the bill for that to exist, and rely on scalable guidelines where possible. So that means writing guidelines, publishing them, identifying hot topics, if you may, and then publishing them so that you know, as many as possible people are going to be able to benefit from the thinking of the regulator. Okay, so how to prioritize implementation after everything I've just said?
Annabel, sorry to interrupt, if I can just
Sure.
request you to wrap up in the next
Definitely,
minute.
yeah, literally the second last slide. So how to prioritize implementation, it's really just three things. So I think it's education and capacity building for government agencies and private companies, especially SMEs. And so these government agencies are important as well, mustn't forget them, because whenever a data protection law passes, a lot of scrutiny is placed on governments, and a lot of government agencies are lost. They don't actually know how to do compliance. So it's really important to think about capacity building for these two groups, actually. Guidelines on hot topics. So these are some examples of hot topics that I think in our experience of being a DPA in Singapore, people kept on asking questions about. So appropriate ways of collecting consent is one. Relying on other bases of processing other than consent, how to do it, that's another one. Appropriate security. So what are good examples of securing data sets and workloads? That's another one. Cross-border data flows and how to do it. That's really important, and that should probably be one of the first ones up there. And use of innovative technologies, that always comes up. And in order to ensure that you don't slow the pace of innovation when a new law like that passes, publishing guidelines on certain things like AI, cloud, IoT, be really important to get people knowing that they can continue to use these technologies and process personal data in a safe way. And finally, enforcement and complaint management. I will end this on this side. I don't want to spend too much time on it at all, but I wanted to talk a little bit also about how to build capacity of SMEs. There are a few tools that are pretty useful. I'm really not going to go through this, but where possible, you know, companies do need to learn how to create data governance frameworks for themselves. So this frameworks apply to the whole data lifecycle. So where the regulators can tell people about this data lifecycle and create simple tools for them, that's really useful. Companies can also outsource some of these things. So if there are international standards that already exist, recognizing them and helping companies know that that certain security standard has been met is quite important. And finally, there are certain existing frameworks that already exist. I've shared some links there, NIMITY and Singapore's PDPC Guide to Developing Data Protection Management Program. These are two really useful resources that exist, you know, for the public to just use, and the Indian government can think about creating similar resources once the act has been passed. So I'm just going to stop there. Apologies if I ran over time, but thank you so much for your attention.
Thank you, Annabel. This was really great. We got a great overview of what different DPAs are doing, and I think you put the capacity constraints in really great contrast. If I can just turn to Professor Shah for his remarks on the subject.
Anirudh, just checking, are you able to hear me?
Yes.
Okay, great. Thanks. This is a really interesting session. This is a really interesting question. I want to come at these questions from a somewhat different point of view. So in this field, there is the substantive content of questions around privacy and data protection. I want to bring a different set of perspectives. I want to place the question of data protection and the DPA in the context of the evolution of the Indian state, looking back at the last 20-30 years. So let's look back at some important milestones. The Prevention of Money Laundering Act and the Enforcement Directorate was a cross-cutting agency which could enforce against players all across the Indian economy. Okay, then we had an organization like SEBI, which was narrow it was about the securities markets. And then SEBI built out conceptual frameworks of the FUTP, the Fraudulent and Unlawful Trade Practices Regulation, where basically once almost any investigation starts, it's going to end in a guilty order. So that's the kind of power that was developed at SEBI. About 20 amendments have taken place to the RBI and SEBI laws of the last 20 years. And in 19 out of these 20 laws, the powers of the regulators went up. There is only one episode that I can recall where the power of a regulator went down. So we should see the DPA as part of this grand arc. It's nice to think about the DPA as being about the privacy of the people, but I can't help have nagging doubts. The present draft law gives a free pass to state surveillance. Similarly, when you think of something like data localization, how can it be of any benefit to force Indian persons to store data in India and not in a GDPR country? So I can't help have many concerns about what is the project that is afoot. And I see this in the context of a larger story, of a grand arc of the establishment of state power and state control over individuals and firms. And we should see that there are long lags through which the opportunities in the law translate into the operational apparatus through which the Indian state is able to influence and impact upon the behavior of individuals. So if you look back at PMLA and ED, if you look back at SEBI, if you look back at RBI, it isn't instantaneous that when the relevant laws are passed, it takes some time for the state capacity to develop and some time for the opportunities in the law to be utilized. And the impact on the economy comes with a lag. So we have seen how private investment in India peaked in about 2007 or 2011. And so I think that in the grand arc, with a lag, the DPA will potentially impact on investment by B2C Indian firms which use computer technology. For example, if you're a hospital in India, then you will need to think about the enforcement apparatus of the new PDP bill and the DPA, and this would adversely impact on such organizations. Now, if we wanted to build this agency properly and we wanted to have good faith assumptions, then what might we have proposed? We would have thought about the entire FSLRC checks and balances about what is a regulator. In the Kelkar and Shah book, we have this whole concept of learn to walk before you run. So in the early drafts of the law, there would have been low executive discretion, low powers of investigation, low punishments. All this is missing in the law. And as we now understand very deeply in India, the text of law is destiny. The words of every law generate the machine where in time the enforcement apparatus and the infringements upon human freedom are going to follow. So I feel that there is a difficult story that is ahead. Now, can something be salvaged? I can think of a couple of ways in which this can be salvaged, and there are some grounds of room for hope. In the case of the financial regulators, there was a whole process which is called the FSLRC handbook, where there was an attempt at writing down rule of law and checks and balances and improvements of administrative law processes that could be adopted by financial regulators, even though these were missing in the law. So the text of the law was imperfect. And the idea was that under some good faith assumptions, could these organizations rise to higher standards of fair play and rule of law? And I think that kind of project is worth attempting. One cannot help notice that in the case of the FSLRC handbook, no financial regulators adopted any of these checks and balances, which is again consistent with the single powerful idea in understanding the evolution of the Indian state, which is that the text of law is destiny. Every vagueness in the law, every piece of arbitrary power in the law will be used in time. It takes time for the state capacity to emerge, but it will be used. But there is another example where actually the agency has worked out better than the law, and that is at IBBI. IBBI has voluntarily adopted concepts of a formal regulation making process, concepts of separation of powers, which were missing in the law. So that's a very optimistic story where even though the law was weak, the agency behaved better than what was demanded of it, of the law. And when I started out in this seminar, I was hoping that that would be the line of attack which Anirudh and Suyash would be pushing, because that's really the heart and soul of the problem, that how do you tie the hands of an agency where the law has given the agency a free pass? Now, there are two other areas where there is room for hope. One very important development is that the jurisprudence on regulators in India is shifting. The courts are changing their view of regulators and regulation in India. So there was a Clariant International order where SEBI was involved. This was 1998. And the Supreme Court was pretty indulgent towards SEBI, that the court recognized that there is a very basic problem in the SEBI law, but they say for the time being, they're going to let it go. And that was, a kind of extreme Chevron doctrine that was present in India. But that's been changing. The Supreme Court demanded higher standards of regulation making of TRAI in the calls dropped order. The Supreme Court demanded a proportionality doctrine of RBI in the cryptocurrency order. There is a group of many orders by courts on the National Tribunals Commission, which, upon careful reading, will raise questions about the judicial process as it is practiced in many Indian regulators. So I think of that jurisprudence on regulators as a new phenomenon, which, if the Constitution of India works and if the judiciary in India works, then it is going to be a new source of progress on re-establishing checks and balances and rule of law on an organization like the DPA. Another room for hope is the recent event where India has signed on a G7 declaration on liberty. And to the extent that this reshapes the international environment for India, then some of the elements of the behavior of India on questions of the economy and the infringements of the freedom of individuals and firms could potentially work out differently. And of course, there is the question of the extent to which there is a feedback loop from the impact on private investment. So we've seen a long development of difficulties in private investment in India, and the DPA will contribute to that. And then we'll have to see what kinds of checks and balances. So in short, there is a world of deep domain knowledge in the field of privacy and good faith reasoning. I personally feel that's not the main game. The main game is about administrative law. The main game is the body of knowledge that was built around FSLRC and the understanding about how the text of law is destiny. The PDP and the DPA creates a new flavor of arbitrary power, and the grand theme is of India's long journey on state power and human freedom. It's nice to engage in good faith discussions about privacy, but that's the world that's been pulled over our eyes. We should look deeper at the phenomena that are at work. Thank you.
Thank you, Ajay, for those remarks. I think it's useful to put the larger issue of data protection regulation in the context of privacy, because those are the larger ends we're trying to protect. But it's also important to think about how to actually equip this DPA with the right powers and tools so that it can actually pursue the powers it's been given with the right kind of mechanisms, rather than under-regulating and over-regulating and causing some of the problems you're alluding to. I think this has been a great discussion. It's given us a lot to think about, and I would like to thank all the participants for giving their time and their inputs into this. Thank you so much, and thank you for all the participants for joining us. Thank you.